everyone, and welcome back to UPC Insights. I'm your host, George Walden. Today, we have another exciting episode as we explore two major topics shaping the Unified Patent Court UPC landscape. First, we'll recap the recent decision confirming the UPC's authority to determine damages even when liability was previously established by a national court. Now, that's interesting. Then we'll look into the controversial topic of long-arm jurisdiction. That's right, I said long-arm jurisdiction, discussing a recent case in Dusseldorf that could extend the UPC's reach beyond the contracting member states. And finally, we'll examine the UPC's first anti-suit injunction and what it means for disputes involving standard essential patents, SEPs. As of last time, our special guest, I'm joined by our expert, Tilman Pfrang. Welcome back, Tilman.
Yeah, hello, George.
So we've got a lot to discuss today, and I hope you can clarify a few things because it is moving fast. So we're going to start with recapping the UPC's reach on damage determination. Tilman, in our last episode, we explored how the UPC confirmed jurisdiction to determine damages even after liability was established by a national court. Now, could you briefly remind our listeners of the key points from that decision?
Certainly, George. Our last episode, we discussed the Court of Appeals decision on January 16, 2025, in which it was confirmed that the UPC has jurisdiction to determine damages even when liability had already been established by a national court.
That's crazy.
That's still crazy. That's still the case. The reasoning was primarily based on Article 32(1)(a) of the UPC agreement, which allows the UPC actually to hear standalone damage determination claims.
Mm-hmm.
Then the court emphasized that as long as the patent was still in force when the UPC agreement came into effect, the UPC can also adjudicate those claims even when the case on the merits was handled before a national court.
Now, that's a crucial point. In your view, what practical implications does this jurisdictional flexibility have for patent holders and defendants navigating cross-border cases?
Yeah, actually significant implications. Patent holders now have more options for damage determination claims because they can now bring these actions before the UPC even after a national court decision.
Okay.
It also offers a harmonized approach to damages determination across multiple jurisdictions, potentially reducing procedural inefficiencies and fragmentation. On the other hand, of course, defendants need to carefully consider cross-border strategies, as this ruling could expose them to additional litigation in the UPC system, which they did not, at least so far not, maybe expect.
So you're saying there's a quid pro quo, which means it could be dangerous if they decide to go cross borders because you might not know what you get.
Yeah, it's a bit on the question on which side you are. I mean, for the claimants, it's a positive decision. For potential defendants, potential infringers, it's a case law or a practice which makes life more difficult.
Oof. Okay, so let's start with the UPC's expanding long-arm jurisdiction. Now that interests me. Let's now dive into the significant development that the so-called long-arm jurisdiction of the UPC, which was discussed in a recent case in Dusseldorf. Could you walk us a little bit through the background of this case?
The case in Dusseldorf dealt with a dispute involving the enforcement of a European bundle patent that included a part granted for the UK.
Okay.
So after Brexit, the UK had to leave also the UPC system, or it left the UPC system, probably it had to. But the claimant in this case argued that the UPC should still have jurisdiction over the UK part of the patent. And this raised, you can imagine, rather complex questions about whether the UPC actually can assert jurisdiction over non-UPC territories and how Article 33 of the UPC agreement should be interpreted.
Interesting. So the decision touches on whether the UPC can assert jurisdiction over national parts of the European bundle patent located outside the contracting member states, like the UK. For what other jurisdictions might this decision be relevant, like the US or New Zealand or Switzerland? I mean, what's next?
Yeah, what's next? That's right. That's right. While this decision focuses on the UK, surely, similar questions could arise for other jurisdictions like Switzerland or Norway. You mentioned also the US and New Zealand. The arm of the UPC might be far-reaching, but maybe not so far-reaching.
Oh, okay, that's a long swim, as they say. Okay.
This is due to the simple fact that there is no national US American part of the European patent or national New Zealand part of the European patent.
Okay.
I mean, it's a European patent. This does not mean that, for example, there are extension states such as Cambodia or Morocco. So for that countries, it may be relevant, the long-arm jurisdiction, but not for countries such as New Zealand, which have nothing to do with the EPO system.
Dealing with the Europeans, for instance, if New Zealand and Switzerland or the US are dealing with the European patent thing, is different rules apply, or is it just something that is not, or would you have to go to their jurisdictions or something? I don't.
Yeah, well, I mean, if you're just domiciled in US America, or you have your seat there, then of course the UPC can also be relevant for you. It's just a question whether, for example, UPC could base a judgment on a US patent.
Okay.
And the UPC cannot, under no circumstances, at least there's no way to go to the United States based on a US national patent for the UPC. There we have the US courts. Same New Zealand. Different, however, for countries. You mentioned Switzerland. I might also mention Norway.
Yeah.
Where there is national parts of the European patent. There is a potential Swiss part of a European patent. There is a potential Norwegian part, or similar, by the way, in Turkey. There's a Turkish part, also not member of the European Union and also not a signatory of the UPC agreement. So the decision we're talking about will be very likely also be relevant for those countries. So let's say European countries, which are not member states of the European Union and therefore not member states of the UPC system.
Gotcha. So then critics have raised concerns about potential jurisdiction overreach, and that's got to be a big concern. Do you think the rulings open the door to forum shopping, or is it more about harmonizing litigation across borders?
Yeah, well, critics are understandably concerned about forum shopping always. However, again, we had a similar discussion also in previous episodes. The court framed actually its decision on a step toward harmonizing cross-border patent litigation. And so while there's a risk that patent holders might strategically choose where to file claims, the UPC, on the other hand, aims exactly to create a unified forum that reduces jurisdictional conflicts. Maybe not so much in that case, but still in the overall picture, this is a driving force for the UPC to be more, let's say, positive in accepting all cross-border cases. If managed carefully, this could benefit both patentees and defendants by ensuring consistency in legal outcomes. I mean, in the end, also the defendants should have an interest in having a single centralized decision. Yeah.
Okay, well then, from a strategic perspective, how should patent holders and multinational companies adjust their litigation strategies in light of this broader interpretation of the UPC jurisdiction? Because, I want to win. If I'm coming to you, I want to win. So, what's the deal?
Yeah, specifically patent holders, because they choose normally the forum where to litigate. So specifically, the patent holders should view this ruling as an opportunity to consolidate their litigation strategies. Now they may be able to pursue a single coordinated action before the UPC, even for patents covering other jurisdictions like the UK or maybe Norway or Switzerland. You can even think about, more difficult, but at least think about Cambodia or Morocco, because there's extension of the European patent. Multinational companies anyway need to assess their exposure to UPC proceedings, of course, and potentially modify their business strategies to minimize their risks in UPC member territories.
So before I get to that, before I get to the next question, how do you go about minimizing that risk? Is it with consultation before you step into the arena of UPC patent court decision? I mean, or how do are you consulted? Would you consult somebody and say, hey, your chances don't look so good, or we might try for this?
Yeah, well, minimizing risk, for example, can simply mean that you should be more careful even about your activities in the UK or Norway, because there might be another court which might also deal with patent infringement, which might have another case law, another practice compared with the national court.
Gotcha.
Let's say, for example, the UPC is more patentee friendly in a specific question of law than the UK courts.
Okay.
And then you must face a potential situation where even if the UK courts would not decide against you in an infringement action, that the UPC might, and therefore take this in your overall equation, I would say.
Okay, good to know. So far, the case and our discussion have involved a defendant with a seat within the UPC territory, specifically in Germany. My last question on this topic is, how long is the arm of the UPC in cases where the defendant has a seat outside the UPC territory?
Very long. Actually, that's short answer.
Okay.
More detailed answer.
Okay.
I would say the UPC's jurisdiction in the discussed case generally relied on the defendant having a seat or significant business presence within a UPC member state, in that case, Germany. However, there is a possibility that jurisdiction could extend even to cases where the defendant operates entirely outside the UPC territory, or at least has a seat, I would say, outside of the UPC territory, depending on the connection to the dispute. For example, if the defendant markets infringing products across multiple jurisdictions and some other requirements, I do not want to go into detail too much, are fulfilled, the UPC may assert jurisdiction. This concept, also, I would even say traditionally known as long-arm jurisdiction, is still developing. We do not have a case law yet, but cases like the discussed one suggest it may play an increasingly important role at the UPC.
You know, it's funny. This everything long-arm jurisdiction, the UPC is just so rapidly it's being opened and defined. You can't define anything yet because it's just developing. Every week, every month is something different, it seems like.
You cannot say it often enough. Yeah, the UPC case law is developing. Every week we learn something new, or at least not entirely new, but something which is decided the first time, like the present case where they covered also the UK territory. And sooner or later, someone will try, or already tries at the very moment, to act against a defendant who has no seat in the European Union, and even then will try to have a long-arm jurisdiction of the UPC.
Nice, interesting. The UPC's first anti-suit injunction. Let's get to it. So Tilman, the UPC recently issued its first anti-suit injunction in a case involving standard essential patents. Could you give our listeners a brief overview of what an anti-suit injunction entails and why it's significant in this case?
Certainly, George. An anti-suit injunction, so not anti-suit injunction. An anti-suit injunction is a court order that prevents a party from initiating or continuing legal proceedings in another jurisdiction or court.
Okay.
So let's say a US court stops a potential enforcement at the UPC. And then your question is about an anti-suit injunction. An anti-suit injunction is a court order that prevents exactly such a party from seeking an anti-suit injunction in another jurisdiction. So it's kind of a defense mechanism of another court in another jurisdiction, maybe the UPC, to avoid that the US court, for example, is getting first an or is ordering first an anti-suit injunction. So in the case now decided, actually already in December, but published in January, the UPC granted such injunction to protect, obviously, its jurisdiction over a dispute involving standard essential patents. And obviously, the court wanted to prevent one of the parties from obtaining an injunction elsewhere that would block proceedings at the UPC.
I get it. I get it. Okay. So then the injunction was granted to the ex parte. So why do you think the court opted for such urgency, and how does this align with practices in other major jurisdictions like the US, the UK, or even Germany?
Yes, you're right. The injunction was granted ex parte, which is still very rare in UPC proceedings, meaning the other party was not present to contest it. This, however, reflects the court's concerns very likely about the urgency of the matter. Waiting could have allowed the other party to secure an anti-suit injunction in another jurisdiction, as said, and then thereby undermining the UPC's authority, of course. By the way, this approach is consistent with practices in jurisdictions like the US, where courts sometimes act quickly to protect their proceedings from external interference.
Okay, that's it's the concern about the urgency of the matter. Is that a tactic that's used to protect, or is that a new strategy, or is that something that should be considered normal going forward?
This is, meanwhile, a thing rather normal going forward. Can call it even the battle of courts.
Okay.
Which court is first, then can at least make some trouble for the other case and for the other court. I mean, in the end, it's still the question how the one court will accept an anti-suit injunction or an anti-suit injunction. But very often legal proceedings is the question who was first, and then.
Okay, and then you go from there.
A lot depends on that question.
So what message does this decision send regarding the UPC's willingness to protect its proceedings and jurisdiction from interference from other courts, particularly in the SEP disputes?
Yeah, well, I think this is a very clear decision which signals that the UPC is serious about safeguarding its jurisdiction. Particularly also in high stakes cases like SEP disputes.
Yep.
And by granting this injunction, the court is reinforcing its authority to handle the complex cross-border cases without any interference from US courts or so. It also highlights the importance of the UPC as a key player in global patent litigation, I think. And patent holders and litigants should take note that the UPC will not hesitate to assert control over cases within its jurisdiction.
So it seems like things are starting to heat up over here. That's what I think.
Yeah, it does, but it's not a new thing. I mean, this is also a kind of a battle is a strong word, but a kind of or cross-border discussion between courts, which is not new. I mean, we have had that between German and US courts and in other constellations. Yeah.
Gotcha. Thanks, Tilman, for walking us through these critical developments. We've covered a lot today, from the UPC's expanding reach on damages to long-arm jurisdiction and anti-suit injunctions. That's a new one. These rulings are reshaping the landscape of the patent litigation in Europe, and it's crucial for everyone in the field to stay informed, and you should do that right here. As always, don't forget to check out our latest blog post on Meissner Bolter websites for more in-depth analysis. And if you enjoyed today's episode, which we did as well, make sure to subscribe and tune in next week for more insights on the UPC's evolving case law. Until then, thanks for listening. Take care. Tilman, see you next time.
See you next time, George. Auf Wiedersehen.
Auf Wiedersehen.